Judgment in the appeal, Youssef and Secretary of State for Foreign and Commonwealth Affairs.
Lord Carnworth will explain the judgment of the court.
The appellant is an Egyptian national who's lived in the UK since 1994. Since 2005, he's been subject to the asset freeze under the United Nations sanctions regime imposed on persons thought to be associated with certain terrorist organizations. Entries on and removals from the list are made by unanimous decision of the UN Sanctions Committee, which includes all the members of the Security Council, including the UK. Listing is implemented in Europe by an EU regulation which takes effect in this country under the European Communities Act 1972. The United Kingdom, as a member of the committee, had originally placed a hold on his designation but later removed it. The appellant claims that evidence on which the committee proceeded had been obtained by the Egyptian government by torture, although he accepts that the Secretary of State himself had proceeded on independent, untainted evidence. The claim failed in the lower courts. There are 4 grounds of appeal to the Supreme Court. First, the Secretary of State, being aware of the tainted nature of the evidence before the committee, had a duty not to lend his support to their decision. Secondly, the decision resulted in serious interference with the appellant's right to peaceful enjoyment of his property, for which there was no specific statutory authority as required as a matter of constitutional principle. Thirdly, the Secretary of State should have applied a higher test than the reasonable grounds to suspect test, and in that respect, the appellant relies on the decision of the House of Lords in Ahmed, a case in which he was himself a party. Fourthly, the High Court had been wrong to judge the Secretary of State's decision by the test of irrationality rather than a proportionality analysis. The Supreme Court unanimously dismisses the appeal for reasons given in a judgment of mine. On the first point, the Secretary of State's decision must be judged by reference to his own reasons, which were untainted. He was under no legal duty to inquire into the possible reliance on torture-tainted evidence by other states. On the second ground, the necessary statutory authority was provided by the European Communities Act 1972, which gave effect to the EU regulation. As to the standard of proof, the test adopted by the Secretary of State was appropriate to the position of a decision-maker trying to assess risk in advance. It was consistent with the approach adopted by the Sanctions Committee, taking account of the recommendations of its ombudsperson in a report in January 2011 and reaffirmed by her in 2013. That material had not been available at the time of the decision in Ahmed, which had also turned on different legal issues. Finally, although the Divisional Court was wrong to lay emphasis on the irrationality test, it had not been shown how a proportionality analysis could have produced a different result. Furthermore, the 2005 decision had been overtaken by the full review of the appellant's case in the light of his more recent activities carried out by the ombudsperson who had confirmed the designation.
The court is now adjourned.